Well, good afternoon again, everyone, and thank you for coming out. Thanks to Andrew and to Tom and others for having me out again. This is the second time I've participated in LaborFest, the first being 4 years ago when I was developing a very different project on Little Steel, and I must say it was very encouraging, that experience, and I'm happy to still be involved with the organization. I'm going to talk a little bit about a theme that was broached in the documentary earlier. Not just broached, developed, but maybe not as far as it should have been, and that is, or could have been, and that is the question of repression and the IWW. The history of this country cannot be understood without comprehending the enormous role that labor repression and anti-radicalism have played in destroying the IWW and helping to eliminate the threat it posed to the rule of capitalism over our society. From the outset, obviously, the IWW was the target of aggressive persecution. Wobblies were frequently assaulted, deported, tarred and feathered, sometimes seriously injured, occasionally even killed. We all know this. They were arrested by the thousands during strikes and free speech fights on the pretext of violating local laws against disturbing the peace, rioting, vagrancy, all of that. And with disturbing regularity, they were framed on more serious charges, including robbery, perjury, and on occasion, even murder. Although largely unstructured, this kind of repression was unrelenting. It was part of the wobbly experience. In part because of it, in part because of a host of other factors like shortcomings in internal organization, the schism that was mentioned in the documentary, chaotic organizing and bargaining tactics, the IWW's membership and overall strength during its first few years steadily eroded. The first decade of its existence, despite a very promising start. As the documentary underscored, the union did win a few notable strikes, and maybe more importantly, electrified much of the working class with its radical challenge to capitalism, its remarkable penchant for dramatic symbolism, and its members' near cult-like physical courage, and their affinity for bold and militant tactics. But as it approached the second decade of its existence, the IWW was, in the opinion of many, on the verge of irrelevance, if not collapse. The union's fortunes changed, though, as the documentary alluded to. Between 1915 and 1916, it devised a method of organizing, the so-called job delegate system, that quickly proved extremely well suited for recruiting members in industries, especially those marked by high levels of itinerant employment. So in that regard, small grain agriculture, lumber, hard rock mining, construction, and some others. This turn to new tactics converged with important political and economic changes brought about by the war. The war enhanced the union's ability to organize as it increased demand for products and services in key industries while simultaneously reducing labor supply. You saw in the documentary this business about the lumber industry in the Pacific Northwest in that regard. As a result of the war and the union's success in organizing, IWW membership, which had dipped to 20,000 or lower maybe earlier in the decade, increased dramatically. It's difficult to make a firm estimate, but by the summer of 1917, membership probably exceeded 100,000, may have exceeded 150,000. Some have suggested even 200,000. In any case, this was significant. This was far in excess of membership in the Socialist Party, for example, and equaled or exceeded membership in a number of prominent mainstream unions of the period. Moreover, the union's influence extended far beyond membership. Its message resonated with many times the number of actual members. You could see this in strikes like the Lawrence strike, for instance, where the vast majority of participants were not members of the IWW, certainly not before that conflict emerged, but submitted, maybe that's the wrong word, acceded to its leadership or its significant leadership of the walkout. Within 2 months of America's entry into the war, however, Congress passed the Espionage Act. Enacted on June 15, 1917, this statute was ostensibly concerned with deterring and punishing interference with the war effort. But it was enacted, and this is important, it was enacted with every expectation on the part of Congress, the Wilson administration, and many elites, both conservatives and progressives, that it would be used against the IWW. And that it was. On September 5th, 1917, federal, state, and local officials, often aided by vigilantes, launched the first of a series of raids on IWW headquarters in Chicago and then later across the country, confiscating tons of material, including and occupying their offices. This set the stage for a series of prosecutions that would eventually put over 160 union members, many of them top leaders, in prison. The basis of these prosecutions under the Espionage Act was alluded to in the documentary. It was the claim that by organizing strikes and engaging in sabotage, the union and its members were essentially engaged in a conspiracy to undermine the war effort. That was the theory of the government's case. In fact, it was almost entirely unfounded. It is true that IWWs engaged in scattered, small-scale acts of sabotage. It is not true that there was anything resembling a nationwide campaign to deploy sabotage, let alone to use it to undermine the war effort. It's true that the IWW was leading strikes during this period. It is not true that the intent behind these strikes was to undermine the war effort, but none of this mattered. It didn't matter in part because the fundamental charge that they faced was the charge of conspiracy, which is very easy to prove, even in the absence of any overt acts of criminality. It also didn't matter because of the reputation of the IWW as a practitioner of sabotage. There remains an active debate today about the nature of the organization's adulation of the concept of sabotage. What did they have in mind when they celebrated it as they did in their iconography, in their publications, in their speeches, and so forth. But regardless, the public understood this, or much of the public understood this, to be an embrace of the most criminal and destructive forms of sabotage on a large scale. It also did not help the union that it was widely regarded as a criminal organization in general. Very much inclined its members to practice violence and to practice serious violence on a large scale. It did not help the union either that the media and the documentary presented this as well, embraced this notion that the organization was an agent of the Kaiser's government in Germany and was in cahoots with it in ways that the Bolsheviks were accused of, and to some extent, one might say, were involved with. In any event, this set the stage for the very easy conviction of these wobblies in 3 trials during that period. I won't belabor the point because I want to turn to something else in just a second, but there are a couple of things worth mentioning about these trials. The Chicago trial was presided over by a gentleman that many of you are familiar with, Kennesaw Mountain Landis, the future commissioner of baseball, who played an important role in maintaining the segregation of Major League Baseball for years beyond the point at which it was put in controversy. The trial itself was the largest. It stands today as the largest conspiracy trial in American history, with 101 defendants, 100 of whom were convicted. 400 separate counts, 4 counts per defendant, involving 10,000 separate criminal charges. The jury deliberated for 45 minutes before convicting them of all these counts. And of course they went to prison, most of them to Leavenworth. Wobblies were not the only people prosecuted on the Espionage Act. I mentioned this in response to one of the questions. About 1,000 people, probably more than that actually, were ultimately convicted under the Espionage Act, most of them being IWW members or members of the Socialist Party's left wing. Without a doubt, these prosecutions were extremely effective. They devastated the Socialist Party, driving out thousands of members, shuttering many offices, and diminishing the activism of countless other members. They also seriously weakened the IWW, decapitating the organization, as many authorities have put it, completely disrupting its business functions and contributing to a significant reduction in membership. But the Espionage Act prosecutions did not finally destroy the Union, which continued to function and organize. Not least, I think, was this because the cases were based in federal law and had to be prosecuted by federal authorities. They were wartime prosecutions under the Espionage Act. They essentially had to be, and they proved too clumsy and expensive to deploy in a comprehensive way. The federal government, by the way, was not nearly as large and potent then as it is today. In terms of numbers of people, number of offices, its capacity to repress was considerably less than it is today. Unfortunately for the IWW, though, the Espionage Act was not the only law its adversaries could bring to bear during this crucial period in the Union's history. Those who wished to destroy the organization also had at their disposal three closely related types of laws that proliferated at the state level and that in many ways proved even better suited to the role of repressing the organization. These were criminal anarchy, criminal sedition, and criminal syndicalism laws. These laws were all closely related. The criminal anarchy and sedition laws tended to be of older vintage, with roots going back, in some cases, to the Alien Sedition Acts of 200, at the time, over 100 years earlier, and to focus somewhat more on sedition against the government. The criminal syndicalism laws were all new to this period. They were rather less focused on threats to the state and more oriented to the criminalization of radicalism in general. And they were, no doubt for these reasons, by far the most important in determining the IWW's fate. The first of these criminal syndicalism laws were enacted in Idaho and Minnesota a month or so before America's entry into the war. Within 3 years, about 20 states and territories and a fair number of municipalities had enacted their own criminal syndicalism laws. The statutes were all very similar. On their face, they criminalized the advocacy of industrial or political change by means of crime, terrorism, sabotage, or other unlawful tactics, as well as membership in organizations committed to such change. Assembling for the purpose of criminal syndicalism was also a crime. Even renting a building for this purpose or serving as a janitor or caretaker in the place could be prosecuted. In practice, though, what these criminal syndicalism laws really did was very simple. They criminalized membership in the IWW and when it emerged in 1919, the communist movement. Indeed, it was for exactly this purpose of outlawing the IWW that these laws were conceived of and enacted in the first place. Everywhere they were adopted, criminal syndicalism laws were pushed through by coalitions of both conservative and progressive legislators who despised the Union and sought its destruction. Occasionally, AFL unionists, jealous of the IWW and opposed to its program, promoted the statutes as well. But always the enactment of these laws was at base the work of powerful business and anti-labor interest, including the Chamber of Commerce and local chambers, state commercial clubs, the Daughters of the American Revolution, and not least the American Legion. Although some jurisdictions, mainly those where the IWW or Communist Party were not especially active, did not bother to enforce their criminal syndicalism laws, many did. And when they did, it was, as the LA Times enthused, with the effect of, quote, making, quote, every red an active criminal. The IWW was the main target of enforcement. From the summer of 1917 through the middle part of the 1920s, at least 1,500 IWW members were arrested on criminal syndicalism charges. Sometimes in the course of strikes and protests, sometimes because they testified in defense of other wobblies, many times because they were picked up in raids by police and vigilantes, but most often simply because police, one way or another, managed to identify them as wobblies. Probably 1,000 were prosecuted to some extent or another. and at least 400 were convicted in scores of show trials, many of them featuring dozens of defendants. In these proceedings, defendants, as a rule, defiantly admitted to IWW membership, and guilt turned on the ability of prosecutors armed with reams of union literature and radical text, which they eagerly characterize as mandates to violence and sabotage, and paid witnesses, some of whom made a living in these cases, to convince judges and juries of the defendant's guilt. So in other words, prosecution was premised on showing this person was an IWW member, that was easy, and then demonstrating to juries that the IWW was a criminal organization. That was done with the literature and the paid witnesses. Most of those convicted were thrown in prison, usually for several years, in some cases for much longer. One man, Neal, a harvest worker arrested in Kansas in 1922 and prosecuted after police found the IWW's red card in his possession, spent 6.5 years incarcerated on this charge. I think he was the longest incarcerated. In prison, these defendants endured atrocious conditions. They were locked in dungeons and strong boxes, they were called, beaten and chained, packed into spaces too small for everyone to lie down. Several committed suicide. Some renounced the Union. But in a stunning testament to the Wobblies' radicalism, their profound sense of solidarity, and their raw courage, most defendants not only endured this treatment, they stood defiant in the face of it. Like several other defendants, Neal, the fellow I just mentioned, spent part of his time in a prison asylum. A liberal reformer who visited him towards the end of his confinement found herself, she said, face to face with a tragedy. But she also found the young Wobbly unbowed and full of courage. And when he was released, Neal wrote his fellow Unionists. He said this: one who goes to prison for the IWW should be proud of his sacrifice for the principle of industrial unionism, and I am justly proud of mine. Defendants expressed their defiance in other ways. Many declined to put on any defense, believing that to do so gave credence to a corrupt and illegitimate process. Scores of defendants refused parole or probation on the ground that accepting this entailed an implicit confession of guilt or an endorsement of a legal and political system which they characterized as nothing but an instrument of capitalist rule. Others, dozens at least, refused release until their colleagues were also set free. The majority of these prosecutions were in western states: Washington, Oregon, Idaho, Kansas, Oklahoma, and especially California, which is where the Union was strongest in many ways in the late 19-teens and early 1920s. The majority of the prosecutions occurred between 1917 and 1927, but there were prosecutions elsewhere, including in Ohio, and they extended past 1927 into the 1930s, where the focus of enforcement shifted to communists, including, again, here in Ohio. In 1929 and 1930, several organizers with the National Miners Union, a communist union, were convicted of criminal syndicalism in the southeastern part of this state, around Martins Ferry, and avoided prison only because an appeals court found technical faults in the way they were prosecuted. These defendants from Ohio were fortunate, though, for among the many remarkable features of this episode of repression is how thoroughly it was supported by the courts. Trial judges consistently ruled against defendants on procedural and evidentiary grounds. They often held the defendants' lawyers in contempt. The documentary mentioned George Vanderveer, who represented the Wobblies in the Chicago case. He was assaulted by vigilantes several times, and several times put in jail in California and Washington, trying to represent Wobbly defendants in these criminal syndicalism cases. The judges in these cases also consistently imposed severe sentences, even in circumstances where juries had recommended leniency. Appellate courts were even worse, for their support for these laws was wrapped up in profound hypocrisy and condescending derision. In the very cases in which these courts, including the United States Supreme Court, upheld the conviction of people charged with these laws, they purported to expand dramatically the protections of the First Amendment rights of free speech and association. Even more revealing is the central role that liberal justices and judges played in this process. Oliver Wendell Holmes and Louis Brandeis, you may know their names, played the lead role in devising in these cases the so-called clear and present danger test. You've probably heard of that, which is celebrated to this day as a bulwark against government infringement of First Amendment rights and a major advance in civil liberties. Except that this test, in fact, was little impediment to these prosecutions, and little impediment either to Holmes and Brandeis joining, as they often did, in supporting these prosecutions. How this happened is pretty straightforward. On its face, this clear and present danger test allows governments to criminalize speech and association if and only if the activities present a clear and present danger. And so what it really did was to admonish legislators, prosecutors, and judges that in order to justify the prosecutions, they should insist that such dangers were indeed present. And so they did, cultivating the most lurid and threatening images of the IWW and the Communist Party. Never mind how contrived it all was, because who gets to decide this at the end of the day? The judges themselves, who in the few cases where they questioned the convictions under this test, did so by dismissing the defendants as too insignificant to bother with. So it was that the criminal syndicalism prosecutions continued largely unabated through the 1930s, making radicalism itself a crime. Again, let me underscore that. These laws in much of the country made radicalism itself a crime. The last significant criminal syndicalism prosecution of a leftist occurred in 1940, when 4 communists who ran a bookstore in Oklahoma City were convicted of running the bookstore. But the statutes were gone. Not until 1969 in another Ohio case, a Supreme Court case called Brandenburg versus Ohio, which involved the rather pathetic escapades of a publicity-hungry Ku Klux Klan leader, did the U.S. Supreme Court finally put these laws in check. In the meantime, even though the prosecutions waned in the 40s and 50s, the federal government enacted what was essentially its own criminal syndicalism law, the 1940 Alien Registration or Smith Act. This was modeled on the criminal syndicalism laws and justified by the same court rulings that justified the criminal syndicalism prosecutions. The law was then used to ravage the Communist Party in the late 40s and into the 1950s, ultimately playing a key role in destroying it as a functional institution. These criminal syndicalism laws were similarly devastating to the IWW. They continued for years after the Espionage Act prosecutions. And unlike riot and vagrancy charges, which were often deployed against wobblies and were disruptive enough, these were very serious felonies. They took a huge toll on the men, mostly men, who were prosecuted. They ruined these men's lives, in fact. They also had what lawyers and criminal justice experts call a deterrent effect. They served notice to those who were not prosecuted what might happen to them if they associated or continued to associate themselves with the Union. Unlike the Espionage Act prosecutions, too, these prosecutions were imposed locally in exactly the places where the Union had been resilient, and by police, prosecutors, and judges, local, who needed no authorization from the President of the United States or the Attorney General or the Justice Department in order to do what it is they did, to make these people criminal for their associations. Of course, there are many reasons the IWW faltered in this period. My argument today, and in the book I'm writing about this issue, isn't that the criminal syndicalism laws were themselves dispositive in this regard. But what I do argue, and what I think the historical record clearly supports, is that one cannot understand the Union's decline without also taking account of what was done to it with these laws. In this story, then, is a lesson about law and the people and institutions that enforce the laws. A lesson about the class politics of police, prosecutors, courts, judges, legislators. Embedded in this is, I think, a still broader lesson about the nature of capitalism. In a capitalist society, capitalists rule. Sometimes they rule by naked force. Sometimes their prerogatives are cloaked in the authority of the law. But always, until they are unseated and their social system consigned to the dustbin of history, they rule. The Wobblies fully understood this. The persecution they endured was the most salient confirmation of this fact, not only for these men themselves, ironically, but also for us, who would do well, I think, to draw from their experiences an understanding of what we must do if we are ever to effectively confront the injustices and cruelties of our time and our world. Thank you.